Item number 1.
Maybe please your motions.
Yes.
My lord, this appeal has been referred, my lord, against the order of the single judge, order dated 16/12/2024, whereby it has been directed to conduct the election by the Executive Committee District Council. My lord, main contest of the case is, my lord, when the writ petition was filed, my lord, on the issue of maintenance was raised, my lord, on the point that the party concerned, the petitioner has got no locus standi to file the instant writ petition. On the point of this, my lord, the argument was placed, submission was there, my lord. Finally, my lord, it was at the time of hearing, my lord, a question was raised whether election is due or not. Election of the headman of the village, Monga Kleshno, was due or not. Well, it was due, and it was agreed also to conduct the election in democratic way, and it was the exclusive right or responsibility of the Hima of Moflang to conduct the election, my lord, to initiate and conduct the election. And only submission was made that due to the sudden demise of one of the member of the Hima Council, the immediately election will not be possible to conduct. So some time was expected to be granted or allowed so that the democratic process can be initiated to conduct the election. But my lord, the order was passed stating that giving responsibility to the Executive Committee District Council to conduct the election. This is the main reason, my lord. Despite the writ petition was not maintained. Well, gist fact of the case is this, my lord. In the year 2022, the headman of the Monga Kleshno was removed from his office of the headman due to some misappropriation of the fund of the government of the village, my lord. In view of this, an active headman was immediately appointed after appointment of the administrator and for the better administration of the village. In spite of this, my lord, the remote headman was interfering with the activities of the administration of the village. Thereafter, my lord, on the before removal of the headman, all necessary process was being followed by the Hima, including giving him ample chance to be heard, but not participated in any meeting, my lord, in a proper manner. Thereafter, my lord, a complaint was filed by an unorganized, unregistered organization by the name of Kasur Nong, which was not registered, nor they were being recognized by the Hima or by the district council. There, on that writ petition, my lord, that writ petition was also challenged on the point of the maintainability. Learned single judge, my lord, after hearing, holding that the petitioner does not have the capacity to file the writ petition. Along with, in the meantime, my lord, a complaint petition was filed before the district council by the same party, which was pending. Learned single judge thereafter passed an order stating that let the complaint petition be heard and proceeded with within 3 months. Thereafter, the district executive committee, district council heard the complaint petition and calling upon the Hima and other parties also, and finally disposed of. The district executive committee, district council, after hearing the parties, has passed an order directing the removed headman to formally appear before the Hima for his grievances. But my lord, he did not approach the HIMA and filed another case by another party, another writ petition by an executive committee, which is also executive committee was not recognized, my lord, before this honorable court as writ petition number 349 and challenging the order of removal. My lord, now the question was there, in spite of the direction, a fair direction, which has been accepted by all the parties, by the executive committee district council, to appear before the formal appearance, formal filing of grievances before the HIMA, which has not been done. And despite, my lord, the removed headman has never been challenged or challenged his removal either before the executive committee district council or before the HIMA or before the court of law. But by other parties, unrecognized parties are being challenged. They are challenging the removal of the headman. On this point, my lord, the learned single judge has passed an order, though considering that the petitioner does not have law custody, but still, for the purpose of the maintainability of the village performance, has directed to the executive committee district council to conduct it. Now, my lord, in appeal, main point on the point of maintainability, that this writ petition was not maintainable. That has to be ought to be dismissed, my lord. On point. Secondly, my lord, main grievances, my lord, as per section 3 of the United Khasi Jantia Hills Autonomous District Council succession and appointment of headman rule, my lord. As per section 3, may I read, my lord?
Section 3.
Section 3, my lord. Election or nomination and appointment of chief and headman. Subject to the provisions of this Act and the rules made thereunder, all elections and nominations and appointments of chiefs and headmen shall be in accordance with the existing customs and prevailing in the elakas concerned, and or in accordance with the orders as the executive committee may issue from time to time. The secretary of the executive committee or any officer appointed by the executive committee in this behalf shall be the returning officer for all the nomination or elections under this section. Now, my lord, here is the question, my lord, that the privilege and the privilege to hold the election, conduct the election, is on the HIMA or chief of the elaka, my lord. Here exclusively as per the customs which has been recognized by this Act, my lord. Therefore, my lord, the single judge order disclosed that there is under orders section 7 rule 3 directed to conduct the election by the executive committee, my lord, district council. Now, my lord, section 7 says confirmation of headmen. It reads like this, my lord: all nominations and or elections of headmen shall be reported to, or as the case may be, conducted by the chief and his darbar, who shall forthwith declare the nomination and or result of the election and issue appointment letter to the person concerned with the information to the executive committee. This is subsection 1 of section 7, my lord. Now, subsection 2 reads, my lord: if any dispute arises regarding any matter relating to or connected with the nomination of headman, the dispute shall be referred by the party or parties concerned to the chief and his darbar on payment of ₹40 for decision. An appeal against such decision shall lie to the executive committee whose decision is final. Now, here also, my lord, the HIMA and chief and his darbar is the authority to be approached, which has not been done. Now, my lord, number 3, subsection 3, notwithstanding anything contained in subsection 1 above, the Executive Committee may, either on application of or its own initiative, conduct the nomination and election of headman and issue appointment letter if the chief and his darbar fails to do. Now, here, my lord, the election has been given by the order of the single judge, my lord, to conduct the election by the Executive Committee, District Council. Now, my lord, here there is nothing has been shown or been expressed as the failure on the part of the Hima of Darbar to conduct the election. As such, my lord, this particular reason is not tenable in the eye of law, my lord. We as a Hima, appellant as a Hima, my lord, is ready to conduct the election. Only, my lord, difficulties were shown, saying that because of the death of one in 3, the decision could not be taken. Now, to conduct an election to any proceed, my lord, the Hima is bound to, bound to discuss with the Darbar and take the decision for fair election. That was the submission before the single judge, my lord, that we want some time to conduct the election. Just the difficulties, there is nothing, no submission, no written was given, my lord, so as to the failure on the part of the Hima to conduct the election. That is the grievances, my lord. We want only the time and conduct the election by ourselves. Otherwise, my lord, it will become a precedent that Hima will not be able to conduct any chief of any elaka, my lord, will not be able to conduct the elections as per the practice and as per the law, my lord. This is the main grievances, my lord. We have already discussed about maintainability, and though it is not, both the cases are not maintainable. And apart from important points are there, my lord. Both the writ petitions and the complaint were not filed by the aggrieved party, my lord. Aggrieved party was the headman who was removed. Never came forward to file any petition against the order of removal. As such, in the previous, and 2 writ petitions were filed, my lord. 1 writ petition 320 and 1 writ petition 349. 349 and 320, the prayers and the subject matters are similar to, both are similar. One was disposed with directing to approve the district council, and another is for conduct the election. With the same ground, both the writ petitions were not maintainable. As such, my lord, our prayer is that to allow us to conduct the election as per the procedure practice of the elector and as per the rule of as per the Act of 1959, my lord. That's my humble submission, my lord, in this particular appeal, my lord.
Yes, who's appearing for anybody for respondent?
I'm here for the.
Yes, Mr. Nath.
Yes, my lord. My lord, here, my lord, district executive committee, the writ petitioner is the party, first party, and the others are, my lord, proper respondents, my lord. All are the those who are party in the writ petition are the parties in the appeal, my lord.
Mr. Kantai?
Lordships, I'm for respondent number 1 and 2. Admittedly, Your Lordship, this Honorable Single Judge has directed us to conduct the election within a period of, preferably within a period of 1 month. I am in agreement with the writ appellant when he says that there is a statute as per section 7 and clause 1 and 2 that the authority to conduct the election or nomination whatsoever is the lingdo, is the chief. And in this case, nothing extraneous has been shown why clause 3 should come into operation. I am also in agreement that let the election be conducted by the lingdo and within a period of 2 or 3 months. And so far, I think that's the limited prayer of the writ appellant. I'm in agreement, Your Lordship. Let the lingdo conduct the election, irrespective of the whatever issues may have arisen in the past. This statute is very clear. When there's a total failure by the LINGDO to conduct the elections, then in that case, clause 3 will come into the picture. In that case, where will come in the picture? So it is not a stage where we have to come in the picture and conduct the election. We also are in agreement that let the LINGDO conduct the election of that headman of that particular village. I think this matter can be closed at this stage itself, Your Lordship, owing to the prayer of the Red Appellant, Your Lordship.
Pursuant to this order of the learned single judge, have you taken any steps for the process to be?
Admittedly, Your Lordship, we could not take any steps because immediately after the passing of this order, there were some holidays, winter vacation for us also. Thereafter, on the first week of Jan, there was a session. We could not take any action. And we are informed that there is going to be an appeal by the LINGDO. So we are also awaiting further direction from this honorable court, Your Lordship. We have not carried out any activities right now, so far the process of election is concerned. I have a suggestion, Your Lordship. The para 6 of the order passed by the Honorable Single Judge at page 21, that can be modified to the extent that I made a submission, Your Lordship. That can be modified. Instead of the District Council, let the LINGDO, let the Red Appellant conduct the election.
No, Mr. Kinta, the projection of situation before the single judge was totally different than what appears to be here. See the submissions made on behalf of the number 2 and 3 who are appellant here, and even the submission which was advanced on behalf of your institution. And now what you are saying is totally opposite to what you made submission before the single judge.
Agreed, Your Lordship. Agreed.
In such
But,
case, you go approach the single bench, file a review application there.
I mean, this is an appeal filed by the Red Appellant. They can go before the single judge again.
Who is appearing for the writ petitioner? Who is appearing for the writ petitioner?
Yes, there is.
Can you?
My lord, read petitioner Mr. S.R. Lindu was appearing.
So who is appearing right now?
Right now, I mean, notice has not been issued, so question of his
Can we
appeal.
dispose of the matter in absence of the writ petitioner?
The issue here is conduct of election, Your Lordship.
But then whose instance the matter came before High Court? There is a writ petitioner on.
Admittedly, yes.
Then
Then let there be notice, Lordship, or the matter can be closed and let them approach
in
again.
absence of the writ petitioner, there is no question of closing the matter. Justice.
You see, the crux of the matter here is only with the holding of the election.
Election, that's the limited
I
issue.
think
Yes.
all the parties are in the same page.
Yes, even the writ petitioner,
As far as the appellant is concerned,
Yes.
you are the LINGDO.
yes, is the chief.
Yes, my lord. Yes, my lord. Yes, my lord.
So you would also prefer to hold the election,
Yes.
Yes, my lord.
and the district council also
Yes, we.
in accordance with the relevant
Statute.
rules, you are, you have to hold the election. But the thing is this:
No, we are not to hold the election. The chief is to hold the election.
as directed by the as directed by the
Single judge, yes.
and according to
Yes.
7.3. But the point here is, as my brother has said, if you have to modify this order, then the writ petitioner has to come.
Has to be heard. Admittedly,
You
yes.
cannot. But if you allow, it would be for your even. I don't find anything wrong with the order of the learned single judge.
Fine.
The point is, election is to be held one way or the other. It will be
Yes, my lord.
it will be for your benefit as well as for the benefit of the whole ilaka or
Village.
Village.
for the whole village for the election to be held. Why would you oppose it if it is held by you or by the district council? Because the acting headman as it is could not be in office indefinitely.
Yes.
And as far as
Yes.
your case, as far as the old headman is concerned, who was removed, he is nowhere in the picture. He has not agitated the matter of his removal before any forum, as you have rightly pointed out. So as far as his case is
Yes.
concerned, there is no case against him
It's a dead
or
case.
for him. So, Mr. Nath, I think in the interest of justice, as my brother
Yes.
has pointed out, you have yourself pointed out that you cannot hold the election in the near future. Near future means what?
No,
It may be,
No, my lord, it was-
maybe
it
1
was-
week, maybe 1 year, maybe 2 years.
no, my humble submission. It was submitted before the learned single judge, my lord, to 1 or 2 months time, just to get the replacement of the military, my lord, who expired. That was the submission, my lord. My lord. And in fact, my lord, the writ petitioner was also not against the holding the election by the IMA, my lord. It was only we have shown our difficulty, my lord, present difficulties, not the future difficulties, my lord. Present difficulty that due to the demise of the military, we are to take the decision. That was the thing, my lord. If we are ready, my lord, to take the to conduct the election. But we do there will be a precedent, my lord, that the HIMA or chief is unable to conduct the election. It is not that fact, my lord. We have
Yes, you get the view.
Lordship,
Yes.
I have a suggestion. Why I got the instruction that let the Lindor conduct the election, because there are two forums of appeal. After the election, there is some grievances by anybody. They can file an appeal before the chief,
That is there.
followed by the executive committee.
That is, see, we are,
I have explained to my colleague also. I said there are forums of appeal in case of some problem in the electoral process. But if you are to conduct the election, there will be no other forum except to come by way of a writ appeal, and that also perhaps may not be maintainable under 226.
Mr. Kinta, problem is that the projection of situation is totally different than what we get from the order of the single judge. Now, is it not that if you say that that thing is not right, you go and approach the single judge again, file an application for recalling this order, and get an appropriate order?
That's a fair suggestion.
Because you see, like you are projecting a case on a different situation now.
No, the issue here, we are concerned only with election. We are not going to
I
the...
understand, we are sitting in an appellate jurisdiction. We are not, that is what.
That's what we also want. Their argument,
Your submission.
argument before a single judge is that intermittently they cannot conduct.
But then see,
But
your
here they have come.
Your submission, Mr. Not submission, which has been recorded in the single bench order and which appears before us now, totally different.
Let's hear from Mr. Steve is here.
There is no question of hearing. The change of situation, that is what.
We also want
See
to...
your own submission, what has been made before the single judge. Go through, see paragraph 4.
I've seen, I've noticed.
You make single judge to pass a certain kind of order basing on your submission. And now you change, take a somersault, now you change your submission and you want this court to pass a different order.
No, Your Lordship, I'm just in agreement with what the red appellant wanted. It's not that I've changed my thing.
Mr. Kinta, we appreciate your submission, especially that part, technical part, that this appellate authority, the parties will lose the form of it. We can understand, we appreciate that also.
They can
But
always...
It is not that, it is not that. What we are saying, the basically conduct of all the parties. You present a different case before a single judge and you come and present it.
No, there are 2-3 matters regarding land compensation being paid to the wrong parties, etc., etc. We'll not look into that, Your Lordship.
That is not a concern.
We do not want to look into that. We are more interested with the election. Let it be conducted at the earliest. That's what we wanted, Your Lordship.
So without the writ petitioner being present, then we cannot. Notice has to be.
Lordship,
Let notice go.
Lordship, for the respondent number 8, Lordship,
My Lord, notice can be issued, my Lord. In the meantime, my Lord, we have an interim prayer also, my Lord.
Therefore,
Executive Committee, Monga, please now.
you are the respondent.
Yes, Lordship.
Or you are the writ petitioner.
Yes, Lordship.
But then he's here.
I have received instruction, Lordship, I'll find my.
Yeah, he's here.
Or you have only received. You have not filed your power.
No,
Yes, sir.
It came to my knowledge this morning that the appeal is fixed today, Lordship. I received instruction to appear, but I have not filed my power, I'll file the course of the day.
But are you instructed in the matter?
Yes, Your Lordship. The circumstances, Your Lordship, in that we have filed the writ, Your Lordship, we want normalcy at Monga, please now. As the term of the headman is over, I was illegally removed from Lordship. So we were aggrieved of the order passed by the District Council in the first round of litigation, Lordship. Then we have filed the writ petition 349, Lordship, aggrieved for the order of the District Council. So direction was given to hold election. So what we want, Your Lordship, from us the respondent, we want normalcy in the entire Monga Please now, Your Lordship. That would be normalcy. Your Lordship, as per the
What is your response to the prayer of the appellant here?
Your Lordship, we want election. But we do not want that Lingdo should help, Your Lordship, because there is connivance between the Lingdo and the respondent former respondent number 3, the acting headman. I was illegally removed also because of that connivance, Your Lordship. So
There is no question of connivance. There is no question of.
There is no question.
As far as the process is concerned, it is incumbent upon the Lingdo to conduct the chief, whatever, to conduct the election.
yes,
He will do so in accordance with rules. He will do so in accordance with custom.
yes,
And everyone who is entitled to contest will be allowed. I think that process is already there.
yes.
It's already in place. So at this point of time, we are not going to the aspect of connivance or whatever.
We are going to...
The only thing that the picture that is portrayed now is this. In the light of the direction by the Honorable Single Judge to hold the election for the election to be conducted by the Executive Committee, now the appellant has come with a prayer that he should hold the election.
Yes.
That is also in accordance with the provision, relevant provision.
Yes.
So that is the only issue here. Now you being the
And we will contact
you being the main party,
Yes.
as the writ petitioner, if you have a say in this, we'll hear you. If you oppose, the matter will be heard on merits. If you say you agree with the submission of the appellant, matter will be disposed of at this point of time.
Yes, sir. Your Lordship, the removal Hammond also, he was read as party before the single bench, Your Lordship. And I'm representing on the let notice we serve upon the removal Hatman and hear the matter on merit.
It will be delayed.
As far as the headman who has been removed is concerned, what is his nexus here? He has been removed. He has not come before any forum against his removal. He has not come.
Yes, Lordship.
So why would you are a stranger to him, why would you expose his cause?
Yes, yes. Your Lordship, my humble prayer is that let the election be held at the earliest, Lordship, since the removal that happened also during pendency of the first round of litigation, it has expired. If the matter can, the election be held at the earliest, Your Lordship, that will bring normalcy to the entire system.
It is always there.
It comes back to the same thing. Even if the chief conducts the election, we are going to monitor the election. That
At
we
the earliest, Lordship,
we will
at
monitor the
present,
election.
the situation and circumstances before the village, Lordship, it has escalated. Lord. So, Your Lordship, the escalation, it comes to pinpointing and taking of saying of words and circumstances which has bring a lot of conflict in the village. At the earliest, if the matter is taken up and the election of the Hammond be conducted, whoever the choice of the people is, that will be fair. If a fair election be conducted, Your Lordship, at the earliest.
we have submitted to.
Whether the previous headman has taken part in the has he contested the case? Has he appeared before the single judge?
Yes, Your Lordship.
He appeared.
No, my lord, here is a small fact, my lord. My lord, the previous headman was never was the party in any writ petition, my lord. Later, my lord, he was included as pro forma respondent number 4, my lord. As a pro forma respondent.
He did not
Not
challenge
in
his
the,
removal.
Included at pro forma at his own instance.
His main contention is, Your
My
Lordship,
lord.
for the single bench is he wants a fresh election.
No, here see, look at the order. The order says the acting chairman is the respondent number 3. So apparently he has appeared before the court.
Yes, Lord.
No, the acting is the.
No, it is pro forma 4.
acting appear, my lord.
No, the ex
Yes, Hammond.
headman is
Ex-headman, my lord.
the earlier chairman. Headman. No, acting. Who's appearing for the acting headman?
I mean, I have appeared for the acting headman as well as the Hima Linga appeared by me, my lord.
Where is the? Yes, now I was looking at it. This one. And this is the acting. Oh, he didn't appear.
is confusion is created by you only.
Agreed, Your Lordship. Whatever has transpired before a single judge,
Otherwise, there is nothing.
we don't want to.
Only because there is a change of stance by you. All the parties.
Why I got this instruction? Because I'm acting under instruction. Now the difficulty we are having also is that the election of the MDC is about to take place, and the officers all are involved in the electoral process. We are having some problems to conduct the election immediately also.
This is nothing for you, Mr. If you want, even within 3 hours you can do it. So do not take that.
It's not so simple. You have to issue notices.
There
has to be 7, 10 days, 20 days.
Of notices and filing of nomination, we can understand. And you can understand that, you see.
You want the election to be held at the earliest, and we are in agreement if it is conducted by the chief. We'll monitor. That's what we wanted.
See, if that was the thing, you should not have advanced that submission which has been recorded by the Rangal Single Judge. Read your submission again.
I've gone through here.
And realize what you are saying here. And compare it.
Anyway, we'll record your submission. Yes, Mr. Nar, what about the Mintri? You said the election could not be held because of the demise of the Mintri.
No, my lord. That point of time when the case was taken up for hearing, my lord, that point of time it was early because the demise was recent, my lord. Now, my lord, within 1 month, 1 hour, 2 months, or even after the election of LDC election, we can do it, my lord.
Code of conduct will come. Within 1 month or 2 months, Mr. Nath? How soon can you do it?
Within 2 months. Within 2 months, you can do it, my lord.
What is the time frame given by the under the rules?
There's no time frame.
No, under the rule there is no time. There is no time, my lord. But we understand, my lord. We have also submitted that we will conduct the election in democratic way. We know the election is due. We have to do it. The only problem was that because of demise. Well, within 2 months, I think we'll get rid of it. We'll have another mentee in place of the shared mentee. Then we will be able to do it, my lord. Otherwise, I think the petitioner, Mr. Steve, is also will not object to it.
Your Lordship,
Otherwise,
see, Mr.
it can be ready.
See, Mr. Nath, the direction of the Leonard single judge is for the election to be held within 1 month.
Preferably within 1
month. So it is
it's preferably by the district council.
See, on the same lines, it would be better for you also to adhere to the time frame that was given by the single judge. Do it within 1 month.
Yes.
and moreover, Your Lordship,
You can
my lord, that's submission. My lord, yes. My lord, that LDC election is also there, my lord. So immediately after LDC election, my lord, we will do it.
How would that?
Allowed, my lord.
Would the code of conduct interfere with your process?
No.
No.
I think that 1 month is good enough.
Exactly.
That's not there.
Exactly.
But the participants, exactly, my lord. Participants may be busy, my lord, in elections.
They are asking too much. Let it be within 1 month, Your Lordship.
Lordship, moreover,
If you profess for the customary election to be conducted by
Yes.
you, then you also have to stick to your principles, have it as early as possible.
My lord. My lord.
1 month then. The order dated 16/12/2024 passed in WPC number 349 of 2024 by a single bench of this court has been assailed in this instant appeal. Heard Mr. Icharnath, the counsel for the appellant. Who, in brief, has submitted that the appellant is the Lingdo and the bracket chief of Himam Mauplang Lingdoship. A dispute has arisen with regard to village Kleshnong, among up Kleshnong within the said Lingdoship, wherein the headman of the said village was removed from office. Against such removal, was removed from office, and in his place an acting headman was appointed. Who has appointed the acting headman? District Council or the
by the chief and his daughter, my lord,
was
and the consent of the villagers, my lord. As a meeting was convened, and villagers supported to be to appoint acting.
and the acting
The removal, it was released, announcement was made by the Lingdo itself, not in consultation with the public at large.
anyway.
It never agitated.
We're not going to that issue, Mr. Lindo, because the removed headman has not come in the picture. He has not agitated, so he is happy with his removal. Was appointed in due process. It is also the submission of the Learned Council that in due course a writ petition was filed before this court, before this court by who was filed the writ petition in the first instance?
First instance, my lord, Kasur. It was disposed of then by the executive committee.
True. Was Kunung Toko? A writ petition was filed before this court by an entity called Kasur Nakinong Song Snong, primarily challenging the removal of the then headman of the Lingdoship. This petition was disposed of by this court with relevant direction to the Executive Committee of the Khasi Hills District Autonomous District Council. The District Council, pursuant to the order of this court, had directed the headman who was removed from office to file a formal appeal before the HIMA. Hatuka kitiki ibang tawag leadership ano HIMA. However, the said headman has failed to comply with the said order, to comply with the order. Thereafter, another writ petition was filed by the respondent number 1 herein, exposing the same cause, that is the cause of the headman who was since removed from office. This writ petition, numbered as WPC number 349 of 2024, was disposed of by the learned single judge by the impugn order herein. Next. The crux of the matter herein is with regard to the holding of the fresh election for the office of the headman of Maungap Klesnong village. It is the submission of the learned counsel for the appellant that this court, that the learned single judge in the impugn order has misconstrued the submission made before the court to observe that the chief of the HIMA, itu Maungap leadership, leadership, is unable to conduct the election in the near future, and as such taking recourse to section 7 under bracket 3 of the United Khasi Jaintia Hills Autonomous District under bracket Appointment and Succession of Chiefs and Headmen, close bracket, Act 1959, had instead directed the Executive Committee of the KHADC to conduct this said election within 1 month. The Land Council has further submitted that the case presented before the single judge, as far as the election, as far as the conduct of the said election is concerned, is that due to the death of a mentee of the said HIMA, the process could not be conducted immediately, for which some time is sought for. However, it is not admitted by the HIMA that the election could not be held at all. In this backdrop, the learned counsel for the appellant has submitted that the HIMA is now ready and prepared to conduct the said election within the any time frame given by this court, and as such the impugn order may be set aside or modified accordingly to allow the HIMA to conduct the said election. Mr. B.G.K. Kanta, Learned Senior Counsel, who appears as your special counsel of the respondent number 1 and 2. Number 1 and 2. Number 1 and 2. You are number 1 and 2. I think Mr. Lindor is appearing for number 1.
For number 1.
Oh, see, Mawam. Number 2.
Respondent number 2, KHADC, has submitted that in all fairness, the executive committee of the KHADC has no objection to the prayer made by the appellant, and under these circumstances would prefer that the election be conducted by the appellant herein. Mr. S.R. Lindor, Learned Counsel for the respondent number 1, has also submitted that on instruction, the main concern of the respondent number 1 is for the election to be conducted as early as possible, so that there would be no disruption of the democratic process as far as the election of the headman of the said village is concerned. In essence, the respondent number 1 has also no objection to the prayer made by the appellant herein. Yes, made him a party. But he said he was
My lord, I have a small submission, my lord.
yes.
My lord, in respect to the paragraph 6 of the order, my lord, their direction was there to hand over materials of the office of the headman, because that was key under the lock and key, which the key was
Have you done so?
been taken
Have you
by
handed over? Have you handed over or not?
No, not. No, it's not in my custody, my lord. It was in custody of the remote headman,
It's
my
in
lord,
my custody. We
who
are
was
still
not
waiting.
giving me.
We are still waiting notice and letters from the district council. However, so far we have not received any.
So you hand it over to the.
High Court has directed.
Yes, Lordship. As per the direction that we noticed to be served on.
We'll modify that.
Yes, Lordship. And Lordship, that unfair, utmost fairness and democratic means, without biasness, the election should be conducted.
Should be. It will be.
Yes, Lordship.
Why?
That is the entire circumstances of
If you are,
that.
you see, the process will be conducted, as it should be conducted.
Yes, Lordship.
If there is any,
Yes, ma'am.
if you find any problem with it, the avenues are always open for you to file your complaint or whatever. Next.
So, my lord, those office materials and to be.
Yes, they will hand it over to you.
Hand over in seal box in presence of the Lingdo and the acting headman. So whoever wins, also the election in fairness, they can open and look at whatever the records there is that we give it to the chief.
Next. This court has given considerable thought to the submission made by the parties. And would confine itself only to the relevant submission made, that is, with regard to the conduct of the election of the headman of Mongap, please know. It is true that under the provision of section 7(1) of the said 1959 Act, of the said Act of 1959, the election of the headman, is to be conducted by the chief and his darbar. And the provision of section 7(3) is only an enabling provision to allow the process of election of such headman by the executive committee itself in case of the inability of the chief and his darbar to do so. At this point of time, it appears that all the parties are in agreement that the election ought to be conducted by the chief and his darbar. The admission by the respondent KHADC, though contrary to what has been submitted before the Honorable Single Judge, would be accepted by this court. taking into account the entire facts and circumstances of this case. Even the admission by the respondent number 1, who is the writ petitioner, in as much as this respondent 2 has no objection to the election to be conducted by the appellant herein. This court therefore would allow the prayer made in this appeal to the extent that the relevant observation at para 6 of the impugn order be modified effectively. Next. Accordingly, this appeal is allowed to the extent that the operation of the impugn order as directed at para 6 is hereby modified to read as follows: that the election to the post of headman of Mongap Krishnam is to be conducted by the chief and his darbar, big appellant, in accordance with section 7(1) of the said Act of 1959. The same is to be conducted within 1 month of receipt of certified copy of this order. That the necessary documents, keys and other materials of the office of the headman, which are now in possession of the respondent number 1 herein, are to be handed over to the new headman as and when he is elected.
It has to till the election of the new headman, let the key documents material be handed over to somebody, my lord, so that it will not be misutilized, my lord.
He's in agreement to give it to us also.
It is also agreed that in the meantime, during the process of the election, such materials now in possession of the respondent number 1 are to be handed over to the Secretary of the Executive Committee, KHADC, who will keep the same in safe possession and who will hand over the same, modify, hand over the same to the new headman, who would to the newly elected headman in due course. I'll change that previous line in view of the above. This appeal is hereby disposed of. No cause.
Lordship, can I make one request? A copy of this order be furnished to us. So we need not.
You'll always get it. It'll be on the net.
Okay.
What is it? You can download it. That copy of this order be issued upon the Secretary Executive Committee,
Yes.
ACDC, for compliance.
Highly obliged, madam.
I'll read only the operative portion. Under the facts and circumstances of the case of the petitioner and the contention and submission of the respective parties herein, this court is of the opinion that the principle founded by the Apex Code in the case of Ajay Kumar Chaudhary, Supra at para 21, in the context of the 90 days period of suspension of delinquent employee, which ought to be reviewed, but if not done so would render the said suspension order infructuous, is applicable to the case of the petitioner herein. Again, adverting to the peculiar facts and circumstances of the case of the petitioner herein, following the law of precedent, this court is bound to adhere to the proposition of law as laid down in the case of Ajay Kumar Chaudhary, Supra, which even otherwise would prevail over the said rule so and so of the Meghalaya Service Discipline and Appeal Rules 2011. As far as the prayer of the petitioner for payment of the subsistence allowance, the learned senior counsel for the petitioner has not made any submission in this regard. The state respondent has, however, adverted in its affidavit in opposition that 75% of the subsistence allowance of the petitioner has been paid, and the further claim of enhanced entitlement has also been processed. This court would allow the process to be concluded as far as this issue is concerned. In view of the above, this court hereby directs the relevant authority to reconsider the case of the petitioner as to the order of his suspension and to reinstate him in service, even to the extent of placing him in any administrative position if permissible under the rules, pending conclusion of the criminal proceeding against him. Accordingly, this petition is disposed of, no cause. Thank you, and a very happy New Year to all of you. And we hope that this New Year will augurs well for all of us.
Yes, Lordship.